Judgment in the appeal, the Queen on the application of Fitzroy George and the Secretary of State for the Home Department.
Lord Hughes will explain the judgment.
The Home Secretary has power under the Immigration Acts to decide if a foreigner's presence in the United Kingdom is not conducive to the public good. A common example is if he's been convicted of offences here. Once that decision is made by the Home Secretary, he is, in the language of the statutes, liable to deportation. The next step is normally a deportation order. In the case of some convictions, a person is automatically liable to deportation. But in either case, it may not be possible actually to remove him. Two common reasons why it might not be are, one, that he might be in danger in his home country, or two, that to deport him would interfere to too great an extent with his human rights, such as his family life in the United Kingdom. Mr. George is in this position. He comes originally from Grenada. He's been convicted of several offences, of which the most serious are supplying Class A drugs. He cannot, however, actually be removed because he has a partner and a young daughter in this country, and the immigration judge has determined that it would be too great an interference with his family life if he were to be expelled. So the question in this case, in general terms, is what exactly is the immigration status of someone who is liable to deportation but cannot actually be deported? The more particular question relates to his formally granted leave to remain. People from outside the European Union who are allowed to enter this country as inwards migrants are granted what is called leave to remain. It might be temporary or conditional, or it may be, and often is, indefinite. The Act of Parliament says that if a deportation order is made, that invalidates any leave to remain. So what happened in this case, and no doubt in others, is that a deportation order was made, but then had to be revoked when the immigration judge decided that there were human rights reasons which prevented Mr. George actually from being deported. So the question then became, does the indefinite leave to remain which he formerly had, which was invalidated by the deportation order, revive when the deportation order was revoked? Alternatively, given that he cannot actually be removed, does the Home Secretary retain the power to regulate his continued presence here by limiting his leave to remain or imposing conditions on it? All that depends on the true meaning of the section of the Immigration Act 1971, which provides that the leave to remain is invalidated if a deportation is made. The Court of Appeal had held by a majority that the indefinite leave to remain did revive. The conclusion of this court is unanimously that it does not. The deportation order has invalidated the indefinite leave. For 40 years since the Act was passed in 1971, all the immigration rules made under it have expressly assumed that the invalidation stands and leave to remain is not revived if the deportation order has to be revoked. True it is that Mr. George cannot actually be removed, but he remains someone whose presence in this country is not conducive to the public good. The court concludes, is not only what the Act says, but it makes sense that the Home Secretary should have power to regulate his remaining here. The legal obstacle to his removal may last indefinitely, but it may not. In a case where the obstacle is a risk of ill treatment at home, the regime may change and the risk disappear. In a case where the obstacle is family life, a person's domestic circumstances may change fundamentally. In either case, there's no reason why removal should stay impossible, as it would if indefinite leave to remain were to be held to have revived. For those reasons, which are more fully set out in the judgment, the Home Secretary's appeal is allowed.
Court is now adjourned.